Hello and welcome to this IQPC podcast presented in conjunction with the Global Patent Congress 2011. I'm your host today, Helen Windsor, and I'm joined by Duncan Park, Leading Counsel of Intellectual Property at Statoil. Duncan, welcome to the show. How are you today?
Not too bad, thank you.
Great of you to join us. Now, just to get some background, if you don't mind answering, what is your background and how did you get into your current role as Leading Counsel of IP at Statoil?
Right. My personal background is I'm a British national. I was born and grew up in England. My technical background is I'm a qualified engineer at engineering at university. My legal background is I'm a qualified UK patent attorney and a European patent attorney. I've been in the IP profession for nearly 20 years now. I've worked for private consultancy firms in London and the south coast of England, but also in internal IP departments in Sweden and a couple in Norway as well.
And how did you come to work in your current role? What were the steps that you took?
I was first a consultant for Statoil for about a year and a half, and then an opportunity arose to become a full-time employee. And as part of my initial work was looking at the IP portfolio after the merger. The Statoil merged with a company called Hydro, and so there was a lot of work reviewing the patent portfolio, the IP in that.
So what is the biggest professional challenge for you at the moment, and do you have a plan of how to overcome this, Duncan?
I think the biggest challenge, which makes working for Statoil so interesting, is the wide range of commercial tools that Statoil use when it comes to technology development. We use all sorts of tools, including joint industry projects, technical collaboration agreements, sponsorships with universities, and also seed funds and venture capitalists as well. So you have quite a complex array of different types of commercial tools which affect the different types of IP and IP strategies you may have. The way we try and combat this is we do a lot of IP mapping across our various technology value chains and constantly try to review the IP portfolio to try and identify the valuable IP and look at the value, whether it's commercial value, technical value, legal value, or strategic value.
And what do you think will be the biggest area of change in IP over the next 10 years?
Well, in my area, I'm responsible for the new energy and renewable energy area, and in our area, there's a lot of open innovation and collaboration, and I certainly think with open innovation and the development of research across the internet and cross-border, I think that the IP landscape will change, especially less and less large patent portfolios, less exclusion, using IP to exclude other parties, and more collaboration will take place. And there will probably be more IP used as a commercial commodity as well, so more trading and technology transfer going on.
And then to move on to another point, how do you think that the new focus on society to ensure a better environment will affect the IPR environment?
Well, it sort of leads on from the other question. I think there will be more collaboration. I think that the mix of public and private partnerships will increase. If you're looking at the environment with sort of climate change technologies, some of the issues are so large that it's not going to be an individual company or even group of companies which solve it. It will be a collaboration of the public research institutes, the EU research funds, in collaboration with commerce, in collaboration with the technology developers, the commercial technology developers.
Now, there is also a big debate going on at the moment about IP and IP laws and the best ways to facilitate the development of climate change technologies and the transfer into the developing nations. So, Duncan, can you fill us in on the two sides of this debate, and what are your thoughts on this?
Yeah, there's been, over the last sort of 10, 15 years, a growing focus on how technology will help the climate change issue. And as part of this, there's been sort of two main camps, the developing countries, where the focus is on those countries needing to reduce or help mitigate the amount of, say, CO2, and basically the developing countries are saying that they will need technology to mitigate the amount of CO2 that's emitted. Now, the developed countries at the moment are the ones who, let's say, are the main developers of this technology, and so the debate is whether the IP or the patents that the developed countries and companies own is going to affect the technology transfer to the developing countries. And to help the flow of technologies from the developed to developing, the developing countries are suggesting having either a ban on patenting for climate change technology, or having voluntary patent pools or compulsory licenses. The developed countries who sort of own the majority of technology at the moment say that this is not the best way to affect technology transfer, because from a commercial point of view, it's better having a commercial environment where the companies or who are investing a lot of money in the R&D can have a look ahead and see how they may get some return for that investment.
Yeah.
And also some of the laws at the moment give the chance for countries to have compulsory licensing if say an owner of the technology or an owner of a patent is not using that technology. Then under the existing legal regulations, they can allow compulsory licensing and allow third parties to apply to use that technology.
Okay, thank you very much, Duncan. It's great to get your views on the challenges for the IP landscape at the moment, and we look forward to hearing more from you at the conference itself. Thanks very much.
Thank you.
For further information about the agenda and the speakers that we've got online, please visit www.patentcongress.com. Alternatively, please contact our inquiries team on enquire@iqpc.co.uk or call 0800 652 2363. Thanks very much for listening. We hope to see you there.